One sentence, that's all it takes. One sentence during a routine traffic stop can turn a completely legal firearm owner into the center of a criminal case. And most people don't even realize it's happening until it's too late. You think you're being cooperative. You think you're doing the right thing. But the moment those words leave your mouth, they're no longer just words. They're evidence. And in light of a major Supreme Court decision, what you say to police about a firearm now carries even more weight than most people understand. Because this isn't just about whether you're legally carrying. It's about how your own statements can be used to build a case against you. Today, we're breaking down the exact phrases that sound harmless, but can quietly destroy your legal defense before you ever step foot in a courtroom. And more importantly, the precise wording that can protect you when it matters most. Hi, I'm Sophia. And if you own a firearm or even travel with one, this is something you need to understand clearly because the difference between staying protected and facing serious charges often comes down to a few seconds of conversation. What we're going through today isn't theory. These are real patterns pulled from real cases where law-abiding people believed they were doing everything right until their own words were used against them. I'm going to walk you through 5 of the most common responses people give when officers ask about firearms and why each one can put you at risk. But more importantly, I'll show you exactly what to say instead, so you can protect your rights without making a costly mistake. And stay with me, because the last response is the one that causes the most damage. And it's also the one people say the most without thinking. The first response sounds so reasonable, so straightforward, that almost everyone says it without hesitation. And that's exactly why it's so concerning. An officer asks, "Any firearms in the vehicle?" And you respond, "Yes, I have a firearm." It feels honest. It feels cooperative. But legally, what you've just done is establish possession without establishing legality. And that gap is exactly where problems begin. Because from a legal standpoint, that statement becomes what's known as an admission against interest. You've confirmed the firearm is yours, but you haven't said anything about whether you're licensed, whether you're carrying lawfully, or whether you're complying with specific state requirements, and prosecutors don't fill in those gaps in your favor. They build around them. There was a case involving a licensed carrier during a routine stop who gave a simple version of that exact response. He believed he was being respectful and transparent. But because his wording didn't meet his state's specific notification requirement, that one sentence became the foundation for charges. Not because he was unlawfully carrying, but because he failed to communicate it correctly. That distinction cost him thousands in legal fees and months of stress that could have been avoided with a more precise response. And this is where most people get caught off guard. The law doesn't reward good intentions. It responds to exact language. So instead of defaulting to "yes, I have a firearm," the safer approach, especially in states that require notification, is to clearly establish your legal status without adding anything unnecessary. A simple, structured statement that communicates compliance, not just possession, changes how that interaction is interpreted from the very beginning. And if that feels counterintuitive, the next mistake will challenge your instincts even more because it involves giving what most people think is helpful detail. Imagine the same scenario. You've already acknowledged there's a firearm and now the officer asks, "Where is it?" Your instinct is to reduce tension, to be transparent, to show there's nothing to hide. So you say something like, "It's in the glove box," or "It's under the seat," or "It's in the center console." Again, it feels responsible. But what you've just done is hand over 2 critical elements prosecutors look for: knowledge and control. You've confirmed you know exactly where the firearm is and that it's within your immediate reach. And that matters more than most people realize, because if that location happens to violate a technical requirement, maybe it's not stored properly, maybe it's too accessible under local law, maybe there's a specific regulation about how it should be secured. You've just provided the exact evidence needed to support that charge. There was a real case where a driver volunteered that his firearm was in the center console. He had a valid permit. He wasn't trying to hide anything, but because of how the firearm was stored, that statement became the key piece of evidence used against him. What could have been a routine stop turned into a prolonged legal issue, not because of intent, but because of volunteer detail. This is where understanding restraint becomes critical. You can still comply with lawful instructions, you can still remain calm and respectful, but volunteering specific location details introduces risk that doesn't benefit you. And once it's said, you can't take it back, because from that point on, it's no longer a conversation, it's documentation. And that documentation can follow you all the way into a courtroom. Now, here's where things get even more deceptive, because the next response sounds not just reasonable, but responsible. An officer asks about firearms and you say, "I have my permit." On the surface, that feels like the safest possible answer. You're signaling that you're following the law, that you're authorized, that there's nothing to worry about. But the risk isn't in what you intend, it's in what happens next. The moment you make that statement, you've invited verification. And if there's any issue with that permit, something you may not even be aware of, you've just created a second problem on top of the first. Permits can expire. They can be suspended without your knowledge due to administrative issues like an unpaid citation. They may not be recognized across state lines the way you think they are. And if an officer checks and finds a discrepancy, your statement, "I have my permit," can now be interpreted as providing false information to law enforcement. That's a separate charge in many jurisdictions, and it often carries its own penalties independent of the firearm issue itself. There was a case where a driver genuinely believed his permit was valid. He had moved, missed a notice, and didn't realize it had been suspended months earlier. But because he confidently stated he had a valid permit, that statement became part of the prosecution. What started as a routine stop escalated into a much more serious legal situation, not because of intent, but because of assumption. And that's the pattern you're starting to see. It's not about whether you're a responsible person. It's about how your words interact with systems designed to verify, document, and when necessary, prosecute. So instead of making definitive claims in the moment, the safer approach is to avoid locking yourself into statements that can be immediately challenged. Precision matters, timing matters, and sometimes restraint protects you more than reassurance ever could. Which brings us to the next response. And this one catches people because it feels like the most human answer you can give. The officer asks why you have a firearm and you say it's for protection or for self-defense. That sounds logical. It sounds responsible. It sounds like exactly what you're supposed to say. But legally, what you've just done is establish intent. You've confirmed that the firearm isn't just present. You intended it to be accessible for use. Now, that might not sound like a problem if everything about your situation is perfectly compliant. But if anything is even slightly off, wrong location, restricted area, permit issue, jurisdictional conflict, that statement can be used to elevate the seriousness of the situation, because now it's not just about a technical violation, it's about intentional conduct. And that distinction can significantly change how a case is charged and argued. There was a situation where someone carrying in a restricted zone explained they had the firearm for protection due to concerns about safety in the area. From a human standpoint, that makes sense. From a legal standpoint, it allowed prosecutors to argue that the individual knowingly chose to carry in a prohibited space, prioritizing personal reasoning over legal boundaries. And once that argument is on the table, the tone of the entire case shifts. What could have remained a minor issue becomes something much harder to defend. This is why explanations, even well-meaning ones, can create complications you don't see in the moment. Because in that interaction, you're thinking about clarity. The legal system is thinking about intent, evidence, and how your words fit into a larger narrative. If this is making you rethink how these situations actually work, that's the point. Because most people don't realize how quickly a simple conversation can turn into a structured case. And in the next part, we're getting into the response that causes the most damage. The one people say instinctively when they feel pressure, and the one that can quietly dismantle nearly every defense you might have. The final response is the one that shows up again and again in real cases. and it usually happens in a moment of pressure. The officer finds the firearm, or the situation suddenly feels more serious and instinct kicks in. You try to de-escalate, you try to sound harmless, and that's when people say things like, "I wasn't going to use it," or "I forgot it was there." On a human level, that feels like the right move. You're trying to communicate that you're not a threat. But legally, those statements can do more damage than anything we've covered so far, because the moment you say, "I wasn't going to use it," you've just confirmed that you knew the firearm was there. That single admission can eliminate entire lines of defense, especially any argument that you were unaware of its presence. And when you say, "I forgot it was there," you're introducing a different kind of problem: negligence. In some jurisdictions, negligence around firearm storage or transport is itself a violation. So now, instead of reducing the seriousness of the situation, you may actually be expanding it. And it doesn't stop there. Statements made under pressure are often inconsistent. People add details, they try to clarify, they say more than they planned. And every additional word becomes something that can be examined, compared, and if necessary, challenged. If physical evidence doesn't perfectly match what you said, that opens the door to credibility issues. What began as an attempt to calm the situation can end up complicating it in ways that are very difficult to undo. There was a case where a driver trying to be cooperative immediately said he had forgotten a firearm was in his vehicle after a previous trip. That statement alone established knowledge and lack of proper handling. What could have been handled as a minor issue escalated into a charge that followed him well beyond that initial stop. And the critical point here is this: nothing he said improved his situation, but it gave the case structure. It gave it direction. It gave it something to build on. And that leads to a reality that most people don't fully understand until they're in it. A roadside interaction may feel informal, conversational, even casual at times, but functionally it's not. It's the earliest stage of evidence collection. Every answer, every clarification, every volunteered detail has the potential to be documented and revisited later in a completely different context. You might be thinking about resolving the moment. The legal system is thinking about what can be used later. That's why the biggest shift isn't just about memorizing what not to say. It's about understanding your role in that interaction. You're not there to explain your entire situation. You're not there to justify or narrate. And you're not required to fill silence with information that could later be interpreted in ways you didn't intend, because once something is said, it doesn't belong to the moment anymore. It becomes part of a record. And this is where that Supreme Court framing becomes important. Your rights don't operate automatically in the background. They have to be clearly and intentionally exercised. If you don't assert them, the system doesn't pause and ask if you meant to. It proceeds based on what's available, what's been said, what's been observed, and what's been recorded, which means the difference between protecting yourself and unintentionally building a case can come down to a single decision, whether you keep talking or whether you choose to stop. So after everything we've covered, the question becomes simple but incredibly important. What should you actually say? Because in a moment like this, clarity matters more than confidence, and structure matters more than instinct. The goal isn't to over-explain the situation or convince anyone of anything on the spot. The goal is to protect yourself legally while remaining calm and compliant. And that starts with understanding that less is not just more, it's safer. If you're in a state that requires you to inform an officer that you're carrying, then your first step is to do exactly that clearly and directly. A simple composed statement that establishes your legal status without adding unnecessary detail. Not a conversation, not a story, just a clear notification. And once that requirement is satisfied, the next step is where most people go wrong because they keep talking. They try to help clarify, explain, or reassure. But at that point, every additional word introduces variables you don't control. The safest and most consistent way to protect yourself is to transition out of explanation and into assertion. A calm, respectful statement that draws a clear boundary. I'm exercising my right to remain silent and I want counsel present. That's it. No elaboration, no justification, no added detail. It may feel uncomfortable in the moment, especially if you're someone who naturally wants to cooperate, but legally that single sentence does more to protect you than anything else you could say. And here's why this works. It stops the flow of information at the source. It prevents misunderstandings, misstatements, and inconsistencies from developing. It ensures that anything that needs to be clarified or addressed happens in the right setting with the right guidance. Because once you've invoked that right clearly, the dynamic changes. The interaction is no longer about gathering statements. It shifts into a different legal posture entirely. Now compare that to everything we've discussed so far. Saying yes, I have a firearm confirms possession without protection. Saying where it is establishes control and accessibility. Saying you have a permit invites verification that can backfire. Explaining it's for protection introduces intent. And panic statements like, I forgot it was there, or I wasn't going to use it, can dismantle entire defenses in seconds. Each of those responses feels natural in the moment, but each one creates a layer of risk that builds on itself. So instead of reacting, you're replacing instinct with a simple structure. Comply where required, then stop talking. Not because you have something to hide, but because you understand how the system works. And that understanding is what separates people who protect themselves from people who unintentionally complicate their own situation. Let's lock this in clearly. 5 responses to avoid and why they matter. Yes, I have a firearm because it establishes possession without legality. It's in the glove box because it proves knowledge and control. I have my permit because it opens the door to verification issues. It's for protection because it introduces intent that can escalate charges. And I forgot it was there or I wasn't going to use it because it confirms knowledge and can destroy multiple defenses at once. Different phrases, same outcome, they give structure to a case that didn't need to exist. And on the other side of that, one clear, controlled response that protects you. You notify if required, and then you assert your right to remain silent and request counsel. Simple, repeatable, and legally grounded. Because in situations like this, it's not about saying more, it's about saying the right thing and then knowing when to stop. By now, you can probably see the pattern, and it's not about memorizing a list of helpful or unhelpful phrases. It's about understanding how quickly a normal interaction can turn into something much bigger based entirely on what you say in the moment. Most people don't get into trouble because they intended to violate the law. They get into trouble because they treated a legal situation like a casual conversation. And those are 2 completely different things. When you're standing there answering questions, it can feel like the fastest way out is to explain everything clearly, to be open, to show you're not a problem. But legally, that instinct works against you more often than it helps. Because once your words are recorded, they don't carry your tone, your intent, or your context. They're interpreted based on how they fit into a legal framework. And that framework is built around evidence, not explanations. That's why the simplest approach is often the most effective. You comply with what's required. You remain calm and respectful, but you don't go beyond that. You don't fill silence with information. You don't try to fix the situation with more talking because the reality is nothing you say in that moment is going to improve your legal position, but it can absolutely make it worse. And this isn't about being uncooperative, it's about being precise. It's about knowing where your responsibility ends and where your rights begin. Because once you understand that boundary, your decisions become much clearer. You're not guessing, you're not reacting emotionally, you're following a structure that's designed to protect you. Now, I want to bring this back to you for a second because experiences vary, and what happens during these encounters can look very different depending on the situation. If you've ever been stopped and asked about a firearm, think about how that conversation went. What did you say? How did the officer respond? And knowing what you know now, would you handle it differently? If you feel comfortable sharing, drop your experience in the comments, not for debate, but so other people can learn from real situations and see how these interactions actually play out. because the more people understand this, the fewer people end up learning it the hard way. And if this helped clarify something that isn't always explained clearly, you can support the channel with a like and subscribe for more breakdowns like this, focused on real-world situations and how to navigate them without putting yourself at unnecessary risk. At the end of the day, this comes down to one principle. You don't protect your rights by saying more.